विद्यार्थियों, उसी के कंटिन्यूएशन में चूंकि हम आपको एविडेंस एक्ट के क्वेश्चन को सॉल्व करा रहे हैं, तो उसी के संबंध में अब हम आगे बढ़ते हैं। एंड फर्स्ट ऑफ ऑल, टुडे आल्सो आई स्पीक इन इंग्लिश ओनली। हियर इज ए कोटेशन, जिंदगी में लगातार मिल रही असफलताओं से निराश नहीं होना चाहिए। इट मीन्स व्हेन यू फेस कंटिन्यूअसली अनसक्सेस, you should not be harassed about these unsuccess, about these your failures. Why? Last key of the bunch may unlock the lock. May unlock. It means लास्ट की ऑफ द बंच, जो चाबी का गुच्छा है उसकी अंतिम जो चाबी होती है वह ताले को खोल देती है, अनलॉक कर सकती है। अनलॉक, इट मीन्स here this is the quotation I have told you. Next, the first question, which one of the following is a fact? There are following statements. Under following statement, which is one of the fact, which is regarded as a fact? Under section 3, fact is defined. Fact is of two types, material fact and mental fact. I have told you, it means material fact and the second one is mental fact. What is material fact? Things, state of things, relation of things that is perceived by our senses, that is called material fact. It means it should be perceived our senses, then such fact shall be called material fact. So here we see Sohan saw a cow. Saw a cow. Saw is a verb, and this verb may be acted, this act may be done, committed by our senses. It means our eyes. With the help of eye, with the help of our sense, that is eye, we can see. So it is a fact. Second one, Mohan said Sohan to go. It is also done with the help of our senses. Sheetal has a high reputation. It is a mental fact. It means all these are fact. Though she is a mental fact, and other is fact issue. Other is, sorry, fact issue not, but you can say that material fact. Cow, you have to go somewhere, it means any place. It is a material fact because these acts are done with the help of, these acts are done with the help of our senses, so these are known as a fact. So all these are fact, so the correct option is D. Next question, which of the following statement is not correct? There are following statements. One statement is incorrect. You have to find out under 4 statements which statement is incorrect. Here we see that a man heard or saw something is a fact, because hearing and seeing is done with the help of our senses. So it is a fact. That a man said certain words is a fact. It is also done with our senses. Next, so it is also a fact. See, that a man has certain reputation is not a fact. Whereas if a person possesses a reputation, holds reputation, it is a fact. Because reputation is known under section as a fact. So this sentence, this option is incorrect, and C the correct answer of the question. So C, because A, B and D, these 3 statements propound facts, but C refers not a fact. It means the question is asked from you, which of the following statement is not correct? This statement is not correct, so the correct answer shall be option C. Okay. Next, question number 3rd. Which of the following is a fact? Which of the following is a fact? That there are certain objects arranged in a certain order in a certain place, it is a material fact. Under section 3, material fact is defined, and in which it is said that a thing, a state of thing, or thing, a state of thing, or relation of things that is perceived by our senses, that is called material fact. So A is material fact, here A option. B, that a man heard or saw something, it is also a fact. because perceived by senses. If you see, you can see with the help of your eye. If you hear something, it means with the help of your ear, you can hear, you can hear. So it is also a fact that a man said certain words, saying something, it is also propounded, it is also said with the help of our tongue, with the help of our mouth. So it is also a fact. It means all of the above are facts. So the correct answer shall be D. The correct answer shall be D. Here A, B and C correct answer. Next, under the law of evidence, the relevant fact. Under the law of evidence, the relevant fact. What is relevant fact? Relevant fact is also defined in the section 3 of Indian Evidence Act. Which fact is known as a relevant fact? Which fact is known as a relevant fact? When we say a fact is relevant, a fact is relevant to another if the fact is so connected with other as is propounded, as is mentioned in this act, under the provisions of the relevancy. It means Indian Evidence Act explains relevancy. When a fact rules of relevancy, it means from the section 6 to section 55, rules of relevancy are propounded. It means second part of Indian Evidence Act explains rules of relevancy. So if a fact is connected with other fact under the rules of the relevancy propounded in the Indian Evidence Act, second part, then it is said, it shall be known, fact is relevant fact. So connection of a fact from other shall be under the rules of relevancy mentioned in the second part of Indian Evidence Act. Then the first fact shall be called relevant fact. So we can say that must be logical relevant. I have told you, relevancy of the fact is propounded under the rules of law mentioned in the chapters, or you can say second part of Indian Evidence Act. It provides legal rules of relevancy. So it is not logical. So the first option is incorrect. Second, must be legally relevant. Yes, legally relevant, but we have to find out correct answer. So further we see, must be legally and logically relevant. No, must be legally and logically relevant and admissible. Here the question relevant fact. So admissible admissibility of a fact is another topic. So D is also incorrect. Legally and logically relevancy, it is also incorrect. The correct answer shall be B, because legal rules of relevancy is propounded in the part 2 of Indian Evidence Act. So if a fact is connected with another fact under the provisions mentioned in the Indian Evidence Act from the section 6 to 55, that is second part of Indian Evidence Act, that fact shall be called relevant fact. So the correct answer would be B. This is the correct answer. And so next question, facts in issue means. Facts in issue means, what is fact in issue? The main disputed fact. It means if the parties have offered their consent, if the parties have offered their dissent, not consent, over a fact, and on such fact ability, rights, liabilities, disabilities are defended, such fact shall be regarded as a fact in issue. It means if a fact of the case, of the matter of the case, if a fact of a case is mentioned in the case are propounded in such a way that rights, liabilities and disabilities of the parties are dependent upon such fact, and a party admit and other party denies, such fact shall be called fact in issue. Then fact in issue means, what is the meaning of fact in issue? What does it mean? The fact in issue means fact existence or non-existence which is admitted. I have told you, if A admits, then B denies. If A admits, then B denies. If there is a fact about this fact, A admits but B denies. The denial of B, acceptance of admission of A creates a dispute. So this fact shall be called fact in issue, because rights, liability, disability are based upon such fact. Okay, so it is incorrect. Second, fact existence or non-existence of which disputed by the party. Yes, there is a dispute between the parties. relating to the fact. Some say, yani one says that existed, and other denies its existence. It means it creates a dispute between the parties. So the option B is correct answer. And let us see. Fact existence or non-existence of which is not disputed, it is also incorrect, and all of the above. So option B is correct answer. Okay. Next question, question number 6. A is tried for murder. A is tried for murder, or B intentionally beating him with a club, causing his death. Which of the following facts are issue? Issue means fact in issue. Which statement, which of the following facts are known fact in issue? I have told you the crux of the matter is fact in issue. In short, you can say that crux of the suit, crux of the matter, crux of the case shall be called fact in issue, because there is a dispute between the parties on this fact, over this fact. Some, it means one admits and other denies. Here see, A is beating B with club. Students, it is not correctly printed, typed. So it means murder to B, not R. A is beating B. It means A beats B with club. It is a fact in issue. A is causing B's death by such beating. It is also a fact in issue. A's intention to cause B's death. A's intention, it means A has the intention to kill him, to kill B. So he started beating, and he beats B to death. And so all these options A, B, C are correct answer, and in brief D is the correct option of the question 6. Question number 7. Question number 7, what does say? Facts alleged by one party and denied by other in a case are termed as facts alleged by one party. It means facts alleged by one party and denied by other party. It means there is a dispute between A and B. If it is said A alleged, it means A admitted. A admitted and B denied, then it creates dispute between A and B. So that is a fact. What type of fact? Fact in issue. where there is a dispute between the parties, rights, liabilities and disabilities are based on such fact. A party admits, other denies. That fact shall be regarded as a fact in issue. So, the correct answer of question 7 is D. D is the correct answer. Because it is a dispute, there is a dispute between A and B. A admits and B denies. Next, question number 8. A is accused of the murder of B. A is accused of murder of B. At his trial, which of the following facts may be in issue? May be in issue. It means which fact, which option is fact in issue. Let us see. A causes B's death. It is in issue. A is an honest person. It is not a fact. Sorry, it is not an issue. Why? Because the person is honest or not. It is not a matter. It is not a matter of dispute. Dispute is something other. So, B is incorrect. And B means second. B means second. Third, A had received grave and sudden provocation from B. It is also true. A was awarded for social service. It is not correct. So, the correct answer 1 and 3rd. 1 and 3rd, B. B is the correct answer of the question. 1 and 3rd. 2nd and 4th incorrect. So the option B shall be correct. Okay. Next question, let us see. Question number 9. What are the relevant facts in the following? What are the relevant facts in the following? B knew that A had murdered C. B knew that A had murdered C. So, relevant fact in the following. It is a relevant fact. B extorted money from A. B was married. It is not relevant. B threatened A to make his knowledge public. B threatened A to make his knowledge public. Next, find out correct answer with the help of code. Here B was married. It is incorrect. And other is correct. So, first one, first, second and third. First, second and third. This is the correct answer. This is the correct answer. Correct answer, yes. First, second and fourth. First, second and fourth. Okay. Next question. Question number 10. In relation to expression defined in section 3 of the Indian Evidence Act, which of the following statement is not correct? Facts include not only physical fact, here physical means material fact, but also psychological fact. Psychological means mental fact. Court include arbitrators. Here the not correct, not. It means you have to choose. You have to tick. That is incorrect. The first one is correct. The second one, arbitrators, it is incorrect. An inscription on a stone is a document, it is also correct, because it is a written document. A fact is said to be not proved when it is neither proved nor disproved, it is also correct. So the option B shall be incorrect. The statement is incorrect, but option shall be correct. Okay? Because following statement is not correct. This statement is not correct. Why? Because court does not include arbitrators. Court includes under section 3 judges, magistrate, and any person who is capable to take, who is authorized to take evidences. Arbitrators are not regarded as a court. So it is, the sentence is incorrect, and you have to find out incorrect answer, sorry, incorrect option. This option is incorrect, so the correct answer shall be B. B is true. Next question. Question number 11. Which of the following is not a document as per provisions of the Indian Evidence Act 1872? Which of the following is not a document of the Indian Evidence Act? A map. A map, it is a document. Words lithographed. Lithographed means an inscription on the stone. Inscription on a stone. A piece of metal with inscription, till it is a fact. But further sentence, that was used cause fatal injury. So D is not a document. D is not a document, and so D is incorrect statement. And according to the question, which is not a document, the D is not a document, correct answer shall be D. Any such fact which possesses probative force is called evidence. Any such fact which possesses probative force is called evidence. The definition belongs to whom? Samand Sir Samand has defined evidence, and so the correct answer shall be A. Next question 12. The law of evidence consists of which one of the following? The law of evidence consists of which one of the following? Which statement is correct? The law of evidence consists of which one of the following? Ordinary rules of prudence, legal rules of evidence, rules of logic, all of the above? No. Actually, evidence only propounds legal rules of evidence. It means lawful rules are propounded in Indian Evidence Act. According to such rules, anything, any content is proved, any subject is, any topic is proved. It means any fact is proved that is before the court. So rules are propounded in Evidence Act. But what type of rules are propounded in the Indian Evidence Act? Legal rules. Rules, those are lawful, those are propounded. By the Indian Evidence Act, according to the rules mentioned in the Indian Evidence Act, any fact is proved. So, the correct answer shall be B. The correct answer shall be B of the question. Next question, question number 13. What does it say? Question number 13. The evidence unearthed. Unearthed means showed, disclosed by the sniffer dog falls under. It means if any evidence is unearthed, if any evidence is found, showed by sniffer dog, that evidence shall be regarded under scientific evidence. The case Abdul Razzaq. Abdul Razzaq versus State of Bombay. Abdul Razzaq versus State of Bombay. The Supreme Court held that if any evidence unearthed by the sniffer dogs shall be regarded as a scientific evidence, this evidence is not a substantial evidence. This evidence is not a substantial evidence. It means on the basis of scientific evidence, a person cannot be convicted. It is only corroborative evidence. Only corroborate. On the basis of it, the person cannot be convicted. So the correct answer shall be D. Next question. Question number 14. In which of the following cases decided by the Supreme Court? What? In 2015, it was held that CCTV footage is the best evidence. CCTV footage is the best evidence. It was decided Jasbir Singh Tara Singh, no. State of Karnataka, Chandwasa Kiran Chandar Ansari versus State of Haryana, no. The correct answer is Tommaso Bruno versus State of UP. Tommaso Bruno versus State of UP. In this case, it was propounded that Supreme Court propounds that CCTV footage is the best evidence. Supreme Court explains. So the correct answer shall be D. Next question. Question number 15. Oral evidence is acceptable. Oral evidence is acceptable only when it is to be produced before the court. The term evidence is defined in the Section 3 of Indian Evidence Act. What is oral evidence? If a statement made by a person before the court with the permission of it, that statement shall be regarded oral evidence. It means any statement made by a person with permission of the court before the court with permission of it. It means the court. Any statement is produced by a person in respect of the fact in issue or relevant fact. That statement shall be called oral evidence. So it is true. Oral evidence is acceptable. Why? Because it is to be produced before the court. Yes, it is produced before the court with consent of the court. And next, can be given anywhere, whether in court or at any other place? No. When it is given in both trial and investigation, I have told you the two words are important in oral evidence: with permission of the court. And the second one is with permission of the court, and the second one is what? Before the court. Permission and before the court, the both is important term regarding to the oral evidence. So A is correct answer. A is the best answer of question number 15. This is the best answer. In comparison to other option, so A is true. Next, which of the following does not constitute evidence within the meaning of section 3 of the Evidence Act? Which of the following does not constitute evidence within the meaning of section 3 of the Evidence Act? Here, tape recording of conversation. It is an evidence. Affidavit is not an evidence, so it is incorrect. Which of the following does not constitute evidence? The affidavit does not constitute evidence, so the correct answer shall be B. Next question. Question number 17. What does it say? Evidence obtained by undesirable means is admissible if it otherwise relevant, though the evidence is undesirable. Undesirable means any evidence is obtained by irrelevant means, but if it is relevant, if it is admissible. Why? Because if that is relevant, it means whether any evidence obtained by undesirable means, if any evidence is obtained by undesirable means, then that evidence shall be admissible if it is otherwise relevant. The court said so. In which case? Now we see that Pushpa Devi Yam Jatiya versus Yam Yal Wadhwa. Hur Prasad versus C.O. Dayal. Kalpanath Rai versus State of Maharashtra. This is not correct. These are not correct. Pushpa Devi Yam Jatiya versus Yam Yal Wadhwa. In this case, the court said so. The Supreme Court said that if any evidence is obtained by undesirable means, that evidence shall be admissible if it is otherwise relevant. So the correct answer shall be A. A is true. Next question. Question number 18. A fact is said to be not proved. A fact said to be not proved. If a fact is said that is not proved, that fact is not proved. Not proved under section 3, proved, disproved, and not proved is defined. Which fact is called not proved? If any fact is neither proved nor disproved, such fact shall be regarded as not proved. So, when it is disproved, when after considering the matters before it, the court believes that it does not exist, when a prudent man considers that the fact does not exist, when it is neither proved nor disproved. D is the, I have told you, not proved, not disproved. Neither proved nor disproved, that fact shall be called not proved. So the option D is correct answer. Okay. Next one is question number 19. A fact neither proved nor disproved is called not proved. That fact shall be regarded as not proved. When a fact is said to be not proved, if that fact is neither proved nor disproved. Okay. Question number 20. Whenever it is directed by the Indian Evidence Act 1872 that the court shall presume a fact, it shall regard such fact. Under Section 4 of Indian Evidence Act, Section 4 of Indian Evidence Act defines the term shall presume. Defines the term shall presume. Shall presume when the term shall presume is used in the Indian Evidence Act, the court shall regard what? That the fact is proved until and unless it is not disproved. Until and unless it is not disproved, that fact shall be regarded as a shall presumed. Shall presume. Shall presume means the fact is presumed to be true, or proved until or unless it is disproved. Let us see. Proved unless and until it is disproved. Proved unless and until it is disproved, or may call for proof of it. Proved not. Proved and shall not allow evidence to be given for the purposes it is a conclusive. So the best answer is A. When we say, what does shall presume mean? If shall presume the term is used in Indian Evidence Act, the court shall regard the fact is proved unless and until it is disproved. So the correct answer of the question is A. It is the correct answer. Question number 21. What does it say? A child below 7 years of age enjoys absolute immunity from prosecution for criminal cases. This is a rebuttable presumption. No. It is not irrebuttable. Rebuttable presumption means shall presume. Always rebuttable presumption means may presume. Actually, it is an irrebuttable presumption of a fact, not irrebuttable presumption of law, not fact. It means it is an irrebuttable, conclusive proof. Because a child below 7 years, if a child is below 7 years, the age below 7 years of age enjoys absolute immunity from prosecution for criminal cases. It means if a person is below 7 years, cannot be prosecuted for any offense. This is not a rebuttable. It cannot be rebutted. It is a irrebuttable fact. The fact cannot be rebutted. And so the correct answer of 21, irrebuttable presumption of fact. This is the correct answer. Question number 22. Which word has not been defined under Section 3 of the Indian Evidence Act? Under following options, any one of the option is not defined. The first one is it means quote, it is defined under Section 3 of the Indian Evidence Act, so it is correct. Fact is also defined. Document is also defined, but confession is not defined. Confession is defined by the court in the case Pakla Narayan Swamy versus Emperor. So, interpretation clause, that is Section 3 of the Act, does not define the term confession. So, D option is correct option. D option is correct option, and D is true. Okay. I have taught you 22 questions. Thank you. That's all.